Someone stole from you. Not your wallet, not your car. Something that actually mattered. Your food, your shelter, the safety of someone you loved. And there was no police to call, no court to appear in, no judge, no jury, no written law of any kind. Just you, the person who wronged you, and 30 other people who all had to keep living together in the same small group for the rest of their lives. What happened next? For most of human history, roughly 95% of the time our species has existed, there were no laws, no prisons, no states, no formal justice systems of any kind. And yet human communities did not collapse into chaos. They did not descend into permanent warfare. They functioned, they cooperated, they raised children, shared food, resolved conflicts, and punished wrongdoers. They just did it in ways that look nothing like what you would recognize as justice today. This is the story of what justice actually looked like before anyone invented the concept of law. And some of what your ancestors used instead is so effective that modern legal theorists are now quietly borrowing it back. Let us start with the most basic question. What counts as a crime when there is no law to break? Anthropologist Christopher Boehm at the University of Southern California spent decades studying hunter-gatherer societies across multiple continents, synthesizing data from over 50 groups in his landmark 2011 book, Hierarchy in the Forest. His conclusion was striking. Across radically different cultures, in different climates, on different continents, the same categories of behavior were consistently treated as serious violations: theft of food or resources, violence against group members, sexual coercion, and, perhaps most importantly, any attempt by one individual to dominate or control the group. That last category is the one that surprises most people. In a hunter-gatherer band, the greatest social crime was not violence, it was arrogance. Attempting to elevate yourself above others, claiming more than your share, acting as if you were better than the group. Boehm called this egalitarian enforcement. And it was systematic, deliberate, and ruthless. The primary tool was something so simple it barely sounds like justice at all. It was gossip. Not idle gossip, strategic gossip, coordinated social information sharing, designed to track, expose, and contain individuals who threatened group harmony. Anthropologist Polly Wiesner at the University of Utah spent years recording conversations among the Kalahari Bushmen and found that roughly 65% of all conversation was about other people, their behavior, their transgressions, their character. This was not entertainment. This was surveillance. Every member of the group was simultaneously being watched and watching others. Reputations were built slowly, over years, through thousands of small observations shared openly across the group. And a damaged reputation in a band of 30 people, where everyone depended on everyone else for survival, was not a social inconvenience. It was a life-threatening condition. The second tool was ridicule. Public, deliberate, sustained mockery of anyone who stepped out of line. If a hunter returned from a successful kill and began boasting about it, even slightly, the group would mock him openly and relentlessly until he stopped. This practice is so consistent across hunter-gatherer cultures that anthropologists have given it a name: obligatory meat sharing with enforced humility. Richard Lee at the University of Toronto documented this in precise detail among the Kung San of the Kalahari, recording cases where hunters who brought back large game were greeted not with praise but with pointed jokes about how small and pathetic their kill was. The hunter understood what was happening. He was being reminded that no single person's contribution made them superior to the group. He accepted it, because the alternative, social exclusion, was potentially fatal. This brings us to the third and most powerful tool in the prehistoric justice system: ostracism. Exclusion from the group. In the modern world, being socially rejected is painful. In the Pleistocene, being expelled from your band meant something close to a death sentence. No group meant no protection from predators. No group meant no help in illness or injury. No group meant no access to the food-sharing networks that kept everyone alive through lean seasons. Anthropologist Sarah Matthew at Arizona State University has studied large-scale cooperation and punishment in traditional societies and found that the threat of exclusion was the single most powerful behavioral regulator in small-scale human groups. more powerful than physical punishment, more powerful than any external authority. People did almost anything to avoid it. But what happened when someone committed a truly serious violation? When the gossip and the ridicule and the social pressure were not enough? When someone killed, or repeatedly stole, or threatened the safety of the whole group? Here is where prehistoric justice becomes genuinely surprising. The group decided, together, collectively. Not through a formal vote, there were no formal procedures, but through what Bohum describes as a slow-building consensus. People talked, they observed, they discussed the transgressor's behavior over days and weeks. Gradually, a shared assessment emerged, and when that assessment reached a threshold, when enough people agreed that this individual was dangerous and could not be reformed, the group acted. Sometimes that action was permanent exile. The transgressor was simply told to leave, with the full knowledge that survival outside the group was unlikely. In some documented cases among groups studied by researchers including Napoleon Chagnon, among the Yanomami of the Amazon, and various ethnographers working with Aboriginal Australian communities, the sanction escalated further. A community decision was made, and one member of the group, sometimes a relative of the transgressor, to demonstrate that no personal loyalty superseded the group's judgment, carried out what amounted to an execution. This was not murder. In the logic of the group, it was the opposite of murder. It was the community's collective decision to protect itself from an individual who had repeatedly demonstrated that they could not, or would not, live within the social contract. Baum documented over 50 such cases in the ethnographic record. In every case, the decision was collective. In every case, it was preceded by a long period of warning, gossip, and escalating social pressure. In no case was it the unilateral decision of a single powerful individual. This is the detail that inverts everything you think you know about prehistoric life. The common assumption is that before law, might made right, that the strongest individual dominated, that justice was simply whoever had the biggest spear. The opposite was true. Hunter-gatherer bands were, by the best available evidence, among the most radically egalitarian social structures ever documented. Not because early humans were naturally peaceful or noble, but because the group had a powerful collective interest in preventing any single individual from accumulating too much power, and the group had the tools to enforce that interest. Every chief who tried to become too dominant found himself suddenly the target of coordinated ridicule. Every bully who attempted to monopolize resources found his reputation destroyed by gossip. Every individual who repeatedly violated the social contract found themselves facing collective exclusion, or worse. The group was the law. Now let us talk about something that almost never gets discussed. How prehistoric communities handled conflict between members who both needed to keep living together. Because not every conflict ended in exile or execution. Most conflicts, the vast majority, were disputes between people who were embedded in the same web of relationships, obligations, and dependencies. Someone took more than their share of meat. Two people wanted the same sleeping spot. A romantic conflict created tension. A careless action caused injury. For these everyday violations, prehistoric justice looked less like punishment and more like what modern legal scholars call restorative justice. The goal was not to punish the wrongdoer. The goal was to repair the relationship, to restore the social fabric, to make the wronged party whole enough that everyone could keep functioning together. Apology, compensation, public acknowledgement of the harm, mediation by respected elders who had no personal stake in the outcome. These were the primary instruments, and they worked because in a group of 30 people, the alternative, ongoing resentment and fractured cooperation, was literally dangerous. A group that could not hunt together, share food together, or defend itself together, died. Conflict resolution was not a moral nicety, it was a survival technology. Archaeologist and anthropologist Douglas Fry at the University of Alabama has spent years compiling cross-cultural data on conflict and its resolution in traditional societies. He found that the overwhelming majority of conflicts in small-scale societies were resolved through negotiation and compensation rather than escalating violence, and that the social mechanisms for doing so were sophisticated, consistent, and remarkably durable across vastly different cultures. So let us reconstruct a moment. It is roughly 30,000 years ago, somewhere in what will one day be Central Europe. A man, call him the transgressor, has taken more than his share from a communal hunt for the third time. Everyone in the group of 28 people knows it. No one has said anything directly. Not yet. But the conversations have shifted. When he speaks, people respond with slightly shorter answers. When the food is distributed, he notices the portions are calculated more carefully now, watched more closely. Two of the older men have been seen talking quietly, glancing in his direction. A woman who was once friendly toward him has begun sitting on the other side of the fire. He can feel it. The social temperature has dropped, and he understands, without anyone saying a word, that he is being assessed. He has a choice. He can acknowledge it, make a gesture of repair, offer something back, demonstrate through behavior that he understands the breach he has created. Or he can ignore it, push further, test the limits. If he chooses repair, the group will likely absorb him back. The conversations will shift again. The social temperature will rise. The assessment will be quietly filed away, but not forgotten. If he continues, the gossip will intensify. The ridicule will begin. The exclusion will creep in from the edges. Slowly, until one morning he wakes up and realizes that the 28 people around him have become, functionally, 27. And the distance between him and that 27th person is growing. This is justice without law. Not blind, not abstract, not administered by a distant authority with no stake in the outcome, but intimate, relentless, and embedded in every conversation, every meal, every sleeping arrangement, every shared fire. You live in a world with courts and prisons and written law, and those things are real and necessary, and represent an extraordinary achievement of civilization. But somewhere in you, in your sensitivity to social temperature, your acute awareness of reputation, your deep discomfort at being excluded, your instinctive tracking of who is contributing fairly and who is taking too much, is the inheritance of a justice system that predates every law ever written. Your ancestors did not need a courtroom to know when someone had done wrong. They could feel it, and more importantly, so could everyone else. The group was always watching. The group was always deciding. And the group, in the end, was always the law.